My presentation has mainly three contents. The first part is about the statistical correlation between the examination results by the examiner at the JPO and the EPO. The second part is more or less the same analysis, but what happens at the opposition and nullity action in the EPO and the JPO. The third part is more detailed analysis of actual cases wherein the EPO and the JPO made different conclusions. The first case is the wine can packaging case, which is a mechanical case. The EPO affirmed and the JPO denied the patentability. And the second case is more pharmaceutical, a biological case. And opposite to, unlike the first case, EPO denied and JPO affirmed the patentability. And we are going to see what happened and why. The first part is the statistical correlation between examination results by the examiner at the EPO and JPO. In order to know what happens if patent applications are filed for the same invention in EPO, JPO, USPTO, and Chinese Patent Office, sometimes called SIPO. We took examples of about 2,500 inventions made in one of these four jurisdictions for which patent applications were filed in the year 2008 to 2010. So 4 applications were filed in those jurisdictions, which make almost 10,000 applications. And we selected technical fields such as the electronics, mechanical engineering, chemistry, biotech, etc. Because from the beginning, we had an impression that the result might be different depending on the technical field. And the examination results have been determined, must be determined by all of these 4 jurisdictions. This is the first result of our analysis, which shows the patent grant rate by the examiner in each of 4 jurisdictions. And this result might be different from the official grant rate published by these jurisdictions because although we took about 2,500 applications filed in those jurisdictions, that corresponds far below 1% of all the patent applications filed in these jurisdictions. So please note that this represents only a small portion of the result, although we took a big number for us. And at the EPO, the grant rate was 51, JPO 57, China 74, USPTO 62. This number more or less corresponds to the official grant rate and our experience in our applications also. And this is the result. What happened? The blue portion on the right, 35%, is the inventions for which patents were granted at 4 jurisdictions. In all jurisdictions, succeeded to get a patent. That was 35%. And the red portion, 20%, which shows 3 jurisdictions decided to grant a patent. Then the green is two jurisdictions. The purple is 1 jurisdiction. The light blue is none of the jurisdictions gave a patent on this. So from this, the number we can derive is if you add this 35% and 15%, which makes 50, but more exactly 49.5, so half of this, all of the results coincided in 4 jurisdictions. The 30% was to grant, 15 was to reject. And for another half, they came to a different decision. And this 50% about number, I wonder whether this is a high correlation or low correlation. I'm not sure whether we should call it high or low, but that reminds me in our mathematics book of statistics, there is an example well known that's the coincidence of birthday or something in Japanese that is called. If in our classroom, if you have 23 children, the possibility that 2 of them has exactly the same birth date is more than 50%. That is amazing. Instinctively, you might think that must be a lot lower, but if you calculate, actually, you will get exactly the same result. So if you keep that in mind, this might be pretty, maybe high, the coincidence. And this is a little more analysis on where the invention is from. The part, EPO here means all these bars are the result made by the EPO. And here indicates where the inventions are from. So if you look at the leftmost blue bar, the result of EPO for the application from Europe. And this is the highest bar, which means that the European applicants has the highest grant rate at the EPO. If you look at the next one, JPO, you might expect that Japanese applicants has the highest grant rate at the JPO, which is 74.5%. And the next one, CN China, IPO authority. It looks like everybody has a very high grant rate, but the highest is the Japanese applicants. And in the USPTO, surprisingly, the European applicants has the highest grant rate at the USPTO. The US applicants, the second, but lower than Europe. And this is the correlation between the decision made by each examining authorities. And overall correlation is about 70%. So pretty high, but I don't know, again, whether you think it's high or not enough. But this is the fact given by our analysis on about 2,500 applications. And the correlation between the EPO and the JPO is 71.5%, which is relatively high. So you can expect, once the EPO grants a patent, you can expect that 71% of that will be granted also in Japan. If rejected, the same. And the highest correlation is observed between JPO and Chinese IPA, 76. Maybe not very much different, but higher than others. That is our introduction of examination results. And then the second part is the statistical correlation between the results of opposition and nullity action at the EPO and JPO. We took the result of opposition at the EPO and nullity action at the JPO. You might know that in Japan, there are oppositions also, but we did not compare opposition because the Japanese opposition system is not exactly inter partes proceedings. Therefore, we do that, we are not comparing apple and apple. So in order to compare apple and apple, we took nullity action at the JPO. And this is the basic numbers of the decisions we took. We focused on the nullity actions filed in the JPO in the year 2016. And there were 130 nullity actions. Not a big number, but this is all filed in this year. And out of which 37 patents had counterpart applications in EP and US. And on which 35 cases had been decided by the JPO. So fortunately, for almost all the cases where they have counterpart in Europe, we had already the decision by the JPO. And for which 12 oppositions had been filed in the EPO. So we can compare the results of these 12 directly between EPO and the JPO. And the table at the lower part shows the number of cases which falls in each category. The left-hand side explains the result of nullity action at the JPO, whether the patent was maintained or patent was revoked. And versus the middle column shows the result of opposition at the EPO, whether EPO decided to maintain the European patent, revoked it, or no result yet. And this is the number, and the correlation we can calculate from, of course, the decisions, two decisions between EPO and JPO is 33%. And this number was surprisingly low for us compared with the high correlation we observed for the result of the examination results. So it looks like that at the level of examiner, EPO, JPO has a good correlation, but when the validity is fought, 33 is shockingly low. It almost indicates if you invalidate in Europe, you will fail in Japan. If you fail in Europe, you will succeed in Japan. That's what it says. So let's see in more detail what happened. And there are not many examples. So as you might see from here, that the split decisions were made in the second line, 7, because the second line, which is number 7, JPO maintained the patent and EPO revoked the patent. And if you go down there, 1 is JPO revoked and EPO maintained. So we focused on this. One example from 7 and one example from the lower 1. This is an example we took, which is our process for packaging wine in 2-piece aluminum cans. I hope nobody filed this application or nobody is a patent owner. And for this, as I said, as written in red in the middle, EPO decided to maintain the patent against opposition, and JPO revoked the patent. Let's see what happened. The claim is pretty simple. The process for packaging wine in 2-piece aluminum cans. And the characteristics is that the wine must be a special wine, which has less than 35 ppm of free SO2, and etc., etc. So there is a limitation about the wine, and can or has another characteristics, coated with a corrosion-resistant coating, as shown blue. And there's one more. They are canned under a pressure of 1.72 bar. So quite simple claim. And these are the arguments made in front of the EPO and the decision by the EPO. You know already that despite this opposition, EPO maintained the patent. Therefore, all the opponents' arguments were rejected by the EPO. But let's see very quickly what were argued and how those arguments were rejected. And the first argument made by the opposition, by the way, the opposition raised almost all possible arguments. So as is the case in many opposition cases, the first argument was that a new matter was introduced in view of priority application. Opponents argued that according to the priority document, it is talking about the 3-piece can, but this European patent is about 2-piece can. There must be something wrong in between. That was the argument, but the EPO's decision was, no, that is not the case. You can consider that 3-piece can is also a 2-piece can, according to this logic. But in the JPO also, this kind of argument succeed rarely. But anyway, they raised this argument and the EPO denied this. And the second argument was the insufficiency of disclosure. And the opponent argued that the free SO2 possibly giving rise to oxidative or microbial spoilage, and the solution for this type of problem is not explained in the patent. Therefore, the disclosure is not sufficient. Or second argument was temperature condition was not described. Therefore, the disclosure is not sufficient. And EPO, again, rejected this argument, saying that this specific measure, patent teaches specific measures how to solve this possible spoilage of the content, and a skilled person is capable of adjusting the pressure and the temperature based on the common knowledge of that technology. That's a common reason to reject the argument. And prior use, the opponent also argued that this type of can was known even before the filing date of this patent, and that was written in the document and submitted evidence D64, D64A. And that was not a strong evidence according to the EPO, because this document do not show any publication date. So it doesn't prove anything with regard to the date, and none of them provides any information on the chloride and sulfate content of the wines, because as you remember, the claim says a particular wine which contains some sulfate and some chloride, lower than a certain level. And lack of novelty, more or less the same thing. The EPO said, no, this document does not indicate a chloride and sulfate content. And the lack of inventive step, this is often a very difficult hurdle to overcome, but the opponents argued, as described here, that the low content of corrosive constituents, this is, and also the packaging of wine coated aluminum container under pressure is strongly studied by this document D29. And D29 indicates that with different contents of sulfur oxide and different coating, and because it provides our kind of mapping for all the variations, to choose a good one out of the teaching of D29 should not have been difficult for the inventor. And the EPO took the same fact and made a different conclusion, which says that it has a vast mapping of many variables. Therefore, to choose the appropriate variable has an inventive step. So that is about these arguments and the EPO's division, conclusion. And then, after some time, almost 10 years passed, and then our nullity action was filed in Japan. And as you know, the conclusion of the JPO was opposite. JPO said, this patent is invalid. Why? The first argument made by the opponent was the lack of enablement. Less than 35 ppm of free SO2 and etc., etc. But it doesn't teach how to obtain such a wine. But JPO board said no, that is not the case, and rejected this argument as lacking enablement because the specification described to some extent how you obtain it, and about the coating may be easily selected in view of the description. And the second argument filed by the opponent was the lack of support. This was the most difficult one. And for this reason, the JPO declared this patent is invalid. And I'm afraid you might see this kind of rejection for your application. The opponent's argument was that there is no description about the detailed content of the wine used for the test, and whether the lacquer used in the test correspond to the anti-corrosion coating. The anti-corrosion coating is a claimed element, is not clear, or content of the lacquer is not clear either. And Board of Appeals said, as described in the lower part, this is the basic idea about the support requirement. The JPO said that in order for a claimed invention to meet the support requirement, the claimed invention must be such that those skilled in the art would understand, based on the common knowledge and the specification, the technical problem to be solved by the invention would be thereby solved. So the subject is those skilled in the art, and the tool is specification and the common knowledge. And the question is whether it is enough to convince those skilled in the art that for the entirety of the claim scope, the problem will be solved. And further, the JPO said that it is not clear whether the test results were obtained due to the free SO2, chloride, and etc. There are test results in the specification, and results was also described. But what was not clear was what's the reason why good results were obtained. It is not clear that the good results are obtained by this low SO2 and low chloride and sulfates. Therefore, this test result does not support the conclusion that this claimed limitation is enough to obtain the results. That was the position of the JPO. And about the corrosion resistant or anti-corrosion coating, it also said that there is one example described in the specification, the last paragraph, but it is not allowed to generalize to a broad idea of anti-corrosion coating based on one example. And therefore, the conclusion of the JPO was that it lacks support. It's enough to invalidate a patent, but it went further and said that, let's see the inventive step, and it denied the inventive step also. And the logic was that the present invention differs from the teaching of D1, which is D29 in the European proceedings. And only in these two things, and they have low free SO2 and chloride lower than a certain level, etc. But the opponents said that all of these can be satisfied by a particular wine produced in Switzerland. And therefore, based on that argument, the JPO took a position that to choose Swiss-made wine to can is not a difficult selection. So it lacks the inventive step also. So that was how it was denied. And I'm afraid I have maybe only 5 minutes. The other example was the opposite. The EPO revoked the patent and JPO maintained the patent. Let's see what happened very quickly. This is a medicament in a biotech field. And what was argued in the EPO was the sufficiency of disclosure. And the basic idea is that it is required that the patent provides some information in the form of experimental test to avail that the claimed compound has a direct effect on a metabolic mechanism specifically involved in the disease. So you are required to disclose the mechanism. And this patent application failed to satisfy this requirement. That was the basic idea why the EPO rejected or declared revocation of this patent. And to the contrary, the JPO said this patent is valid. The Board of Appeals said that first, those skilled in the art would understand by reading the specification that the medicament would take the claimed effects when administered as described in the claim. That is a requirement. So the question is, by reading the specification, the people would, or specialists would understand that would take effects. And the key argument here from the patentee was, it was of course possible because the disclosure by the specification was small. Those skilled in the art had the computer program which applies to these results described in the specification and extend the prediction what would happen for the different application of this patent. And then on that basis, the patentee argued that the disclosure was sufficient. And they succeeded. So although our comparison was limited in numbers, but even from that, we might conclude as follows. First, the EPO and the JPO examiners tend to come to the same conclusion regarding the patentability. The correlation was 71.5%. But once the validity of patents were challenged, the correlation drops drastically. And the correlation is 33.3% between the two jurisdictions. And when conclusions are different, the EPO found the EP patent invalid, while the JPO found the JP patent valid, more often than the other way around. That number was 7 versus 1 case. And the regarding subjective examination at the opposition division of the EPO and the Board of Appeals of the JPO, the former the EPO tend to have higher standards for the sufficiency of disclosure, while the JPO tend to have higher standards for the support and inventive step, the standards. That's about my presentation. And I would like to welcome any questions you may have. Thank you very much.
Thank you, Yoshi. Any questions?